Good morning to everybody, and it's a real pleasure to be here and to chair this session on evidence in discrimination complaints. We have two speakers on the topic, each of whom have been given 20 minutes speaking time. I would ask speakers to speak within the allotted time. This is very important if we are to negotiate today's proceedings on schedule. Following each of the presentations, there will be 25 minutes set aside for discussion. The first speaker that I'm so pleased to introduce to you is Kristin Henrard. Kristin is a professor of law at the Free University of Brussels and a co-director of the Human Rights Centre there. She will talk about the sharing of the burden of proof in cases concerning racial discrimination. Kristin, the floor is yours.
Thank you very much.
Kristin, excuse me.
No worries. Let me share my PowerPoint, if that works. Do you see it?
I do.
You do. Okay, great. Then I am starting my presentation. So thank you, Michael, very much for this introduction. And you already told the people what I'm going to talk about. So let me immediately start. And as you know, human rights are said to be fundamental rights inherent in being a human being. But sadly enough, having these rights doesn't necessarily mean that one can effectively enjoy them. To some extent, this has to do with the fact that rights can legitimately be limited by states, but states also actually violate these rights. And in that regard, one wants to seek redress before a court or a supervisory body. And then it becomes absolutely crucial to know, okay, if you need to persuade the court, and who then needs to persuade the court of what and to what extent? These are the questions of the burden of proof. And, you know, as always in human rights instances, it's a question of fairness, fair balance. On the one hand, you don't want to make it too demanding for the victim to prove his case in order to get an effective protection of the fundamental rights. On the other hand, you don't want an unreasonable burden to be put on the respondent either, and so that the proof is strong enough before the person can be held accountable. It's important to also, and I think that's why it's such an important project is DISSECT, that actually questions of proof go to the core of the matter. It's not just an afterthought. It actually determines very much also the substance of the protection and the extent to which a right is effectively protected. So here, the focus will be on the ECHR and racial discrimination. And once in a while, I will refer to other cases on other grounds because I think they clarify the points I'm making, and it's interesting to see parallel developments. As I was the first speaker, I thought it was also important, but maybe I should have clarified that with Marie-Bénédicte, to give a bit more general points about the concepts. What are we actually talking about when we talk about the burden of proof? And then more particularly the special allocation of the burden of proof and the two phases that consists of. And then I will, of course, immediately go to the ECHR and questions of proof, and then more particularly the proof of racial discrimination cases, where I make a distinction of what happens at the level of indirect discrimination on the one hand and direct discrimination on the other. You see, with direct discrimination, there's a lot more to say about the criteria that have been put forward and some interesting developments that take place in that respect. And it's immediately already important to say that, especially in the latter effect, I'm far from taking any conclusive, coming to a conclusive assessment, because it's always developing, it's always depending on developments in the jurisprudence. And this is also my interpretation of what I see in that, in the case law as that develops, of course. Okay, so the conclusion being a mixed account, as my presentation already said. So on the one hand, you may see a trend in international and national courts to share the burden of proof in racial discrimination cases, but it's still a matter which is in full development, more particularly in relation to the actual criteria that are being used. Okay, so what are we talking about when we talk about proof. There are related issues, but are still related, but still different. The standard of proof is a question to what degree one needs to prove something. And you have several possibilities: beyond reasonable doubt, which is a very high standard, clear and convincing evidence, balance of probabilities. And there's a further distinction that needs to be made between the burden of production and the burden of persuasion. Especially in adversarial proceedings, there's a lot of attention on the burden of production. Who needs to make a move? Who needs to put proof forward? And this can shift back and forth between the parties. But in the end, the most important question is who has the burden of persuasion? Who basically bears the risk of non-persuasion? Who loses the case when the party doesn't persuade the court? And that is really essential here. When you talk about allocation of the burden of proof, it's about the distribution over the parties, who has to prove what to what extent. Quickly going to the baseline at the burden of proof allocation baseline, so to say, and that is according to the Latin phrase affirmanti cumbit probatio, so who claims something needs to prove it. And basically, that means that the applicant not only has the initial burden of production, but also the ultimate burden of persuasion. Now, because that there has been an increasing awareness that it's often very difficult to obtain proof of the facts by the applicant, questions of fairness have urged this emergence of the so-called special allocation of the burden of proof. So what does that look like? That's again thinking about fair balance. When the facts are largely in the exclusive knowledge of the defendant, then it is called upon to, reduce to some extent. BOP stands for burden of proof of the victims, without a disproportionate burden on the defendant either. So what happens with the special allocation of the burden of proof is that there are two phases, and in each phase, a different party has the burden of persuasion. In the first phase, it's the burden on the claimant to persuade the court to establish a prima facie case. Then the burden of proof shifts to the respondent, who needs to put forward a rebuttal and basically saying that there is, proving that there has been no discrimination after all. Relevant questions here then are, okay, so what constitutes, when are sufficient facts proven that the court may establish a prima facie case? And that is mostly related to questions of the causal link between the disadvantage on the one hand and the ground on the other. The second question is, okay, when is the presumption rebutted? Now one can rebut a presumption either by refuting it or by trying to justify the differential treatment. Refuting would be by contesting comparability, or again, contesting the causal link. And then the justification part, that is a typical justification criteria that are used in discrimination cases. Okay, so this was by way of introduction. So let's now turn to the European Court of Human Rights. In terms of standard of proof, the court keeps saying that it uses the beyond reasonable doubt standard of proof, emphasizing that, it may be, but it's not as strict as what happens in national criminal law, because the court doesn't deal with criminal liability, it deals with state responsibility. That's what the court keeps saying. At the same time, it's quite obvious that the standard of proof used is quite demanding for the victim. Nevertheless, if you look at principles of proof used by the court, several of these general principles that the court follows add perspective to this very heavy standard of proof. Because the court emphasizes that there's no procedural barriers and that it engages in a free evaluation of all evidence put forward, also evidence put forward by third parties. And that's, of course, what we often see when that evidence is put forward by NGOs as third-party interveners. And also importantly, the court is very open to draw inferences from facts put forward or facts at its disposal by also the non-parties. The special allocation of the burden of proof. Now, how does the court seem to respond to that? And so the court definitely acknowledges that there are difficulties for the victims to obtain proof of discrimination, and hence, it engages in the special allocation of the burden of proof. And to some extent, this is also in line with steps that are used in the human rights assessment, right? There's two steps that the court always uses in its assessment. First, is there an interference? And if there's an interference, is there a justification for that? And for the interference, the burden of proof would be on the claimant. The justification, there the burden of proof is on the defendant. So, to some extent, it seems to fit. It seems to make sense that the ECHR would apply that special allocation of the burden of proof. And here one can also notice that in regard to racial discrimination in the event that there's been a considerable influence of the Racial Equality Directive of the EU, and for the other grounds, of course, the Framework Employment Directive as well, where there is this also emphasis on the sharing of special allocation of the burden of proof. Now, finally, quickly zooming into this question of racial discrimination, what do we see there? As I said, the court has adopted a different baseline in relation to issues of direct and versus indirect discrimination. And when one reflects on what is the difference between the two, it's basically the differences in the directness of the causal link. With direct discrimination, there's a very direct causal link, not necessarily explicit, but a very direct link, and indirect, and that's more this idea of neutral measures with a disproportionate impact of a particular group without justification. So the link between the disadvantage and the ground is more of an indirect nature. Now, what we see happening is that in relation to indirect discrimination, basically the special allocation of the burden of proof is rather well established, as we very recently saw, or more recently in the Bio versus Denmark case about family reunification measures in Denmark, with a disproportionate effect on people that were not ethnically Danish. What is important here, or what I can say here in terms of development, is that the court was initially very reluctant to even acknowledge this whole idea of indirect discrimination. It took very long until the Grand Chamber decision in the DH versus the Czech Republic case. And what you see happening there, it seems that the acceptance of the idea of indirect discrimination went hand in hand with the development of a specific review model, where this question of proof played a vital role. So the prima facie case of discrimination being established often via statistics, and then the burden of proof shifting to the respondent. So, but that in any event, more or less for indirect discrimination, there it's quite strongly established in the jurisprudence, this special allocation of the burden of proof, the sharing of the burden of proof between the parties. If we then turn to direct racial discrimination, there's a different picture that emerges. Direct discrimination can be overt. Most of the time, it's of course covered because public authorities are fully aware of the fact that they're not supposed to differentiate on the basis of race. When you see in an example of an overt discrimination case would be Timishev versus Russia, where there was an explicit order from a police officer that the Chechens weren't allowed to cross a particular border within an administrative border within Russia. And then you have the court saying, when the applicant has shown that there's been a difference in treatment, then it's for the respondent government to show that that could be justified. So again, that reversal of the burden of proof. But that is, of course, if there is some kind of official document showing that there is a differentiation on the basis of ethnicity being made, that first step is relatively easily accepted. But as I said, in most cases, most cases of direct racial discrimination are of a covered nature, especially when it concerns discriminatory motives for crimes. And there's more to say, and it's much more complicated. Since the Nachova Grand Chamber decision, the European Court has used or has mentioned at least a particular criteria that would determine the distribution of the burden of proof. And that is the specificity of the facts, the nature of the allegations, and the convention right at stake. When you reflect a little bit on that, on these criteria, then it's immediately clear that they don't always point in the same direction. Very specific facts that can be put forward that seems to call for a reduction of the burden of proof of the claimant. When the allegations are very serious, that would point for a higher burden of proof on the claimant. The convention right at stake, again, well, depends. If it's one of those rights that has often been said to be crucial in a democratic society, like the prohibition of torture, one would think that that would possibly reduce the burden of proof for the claimant for the first phase. However, these criteria may often, not always, but often be just mentioned, then they're never really applied in concrete to the facts of a case. So the court doesn't clarify how it uses the criteria, and especially, when these criteria would pull in different directions, how the relative weight would be determined. And to some extent, one could question, avoiding clarifying these criteria, isn't that one of those ways in which the court can avoid evaluating claims of substantive discrimination and just, preferring to go the procedural route? That's something that I will explain in a bit further. So that's a question that was raised. Nevertheless, what we do see is that the court does give special regard to questions of effective access to proof. And when that wouldn't be the case, when the claimant doesn't have effective access, then that has implications for the way the burden of proof is shared. So basically in a case of 2019, I have to read it because it's too complicated, Agdomelashvili and Japaridze. It's a case on LGBT. Nevertheless, it's a police, but I think it's very relevant because what you see happening there, it was a police action in a building of an LGBT organization where it started engaging in strip searches and all kinds of slurs against these the people involved. And there actually, the court actually seems to be saying that when these facts are, the alleged facts are largely in the hands in the exclusive knowledge of the authorities, then it's the entire burden of proof would go to the government, not just a sharing of the burden of proof, but the entire proof would seem to go, and that would be paragraph 43. So so you see that the court is struggling. It seems to see, well, yeah, there needs to be this fairness, and to some extent, not always very principled, but you see that happening, that in particular cases, the court even goes further than the mere sharing of the burden of proof. Now, there have been, here that's what I tried to say, so there have been very interesting developments that show that there is some promise in what's happening in the case law. First of all, there is this question of procedural versus substantive state obligations, CQ procedural versus substantive violations of the prohibition of discrimination. And here we have to go back in time again a little bit. That's the first Nachova case. Nachova concerned a killing of Roma that were fleeing by police officers. And in the first Nachova case, the chamber decision, the chamber actually concluded that because of the lack of investigation in allegations of racism, there was a prima facie case of racial discrimination, putting the burden of proof on the government that couldn't get away with it, and so concluding to a violation. However, the Grand Chamber changed tack, and it said, well, no, that would be an impossible burden of proof on the defendant because a negative proof of racist intent is impossible. And what the Grand Chamber did instead is making a distinction between the substantive violation of the prohibition of discrimination and a procedural violation. And this has been with us ever since Nachova Grand Chamber, 2005. I'm very bad in the exact numbers, but I think something like that. But, and that's what I keep putting it as an interesting development, what you see happening is that every so now and then, there are hints in the case law of a return to Nachova 1, in the sense that there are hints at cases where problems in investigation, so where the public authorities, notwithstanding clear indications that there may be racial discrimination happening, so notwithstanding that, nevertheless, they do not investigate it, or properly, not investigated properly, that influences the burden of proof in terms of violations of the substantive dimension of the prohibition of racial discrimination. You see, for example, in 2013, there's a case like that. I'll explain it in a little bit, but also more recently, the case of the LGBTI. There again, Agdor Melashvili, the court actually said that the failure to investigate implied that the facts as submitted by the applicants were established beyond reasonable doubt, even basically concluding to foolproof, right? If you would imagine, if you would read it like that. In the Adzigitova case concerning ill treatment of the Avar in Russia by public authorities, a very interesting thing happens there is that the court assesses separately the procedural and the substantive dimension. It's actually starting with the substantive dimension, but it doesn't come to a conclusion that there would be a violation of the substantive dimension of discrimination. It just acknowledges that there's a problem. And so the ethnic origin was among the causal factors of the detention and ill treatment. It doesn't formulate a conclusion. It only does so after having found the problems in relation to the procedural dimension. So there seems to be some combined analysis before the court can conclude to a violation. So that's a very recent case, actually the 22nd of June of this year. So really extremely recently. Again, I'm not saying this is a conclusive shift in a conclusive trend, but I want to point out that there are these cases that seem to hold some
Kristin,
developments. Yes, do I need to?
Yes, could you wrap it up, please?
Yes, apologies. Yes, almost few more points.
You've really got another minute.
Okay, well, anyway, procedural obligations, court becomes more demanding in that respect. So it becomes very specific about what needs to be done in the procedural obligations, which implies, of course, this is bound to facilitate the proof by the victim as well, and when the court becomes more demanding on procedural obligations. Finally, quickly, what you see in terms of the shift in the burden of proof, there seems to be an ongoing reluctance of the court to shift the burden of proof in cases of direct racial discrimination. Basically, the court only seems to engage in the shift, the reversal, putting the burden of proof on the respondent government when there's virtually full proof. At the same time, what we see happening is that the court more and more acknowledges questions of institutional racism, even ethnic profiling. I'll just quickly, Anteyev versus Russia, 2014, again, quite strong proof actually, and then the court says, well, there is a prima facie case of racial discrimination. You could actually wonder, isn't there full proof actually in that case? Abdu versus Bulgaria shows the other way around, where there are quite strong indications of a prima facie case, but the court says there isn't, even though it was involving skinheads, etc. So there's still this, not clear line. Okay, sorry, this goes bubble. Lingurar versus Romania, again, virtually conclusive proof about institutional racism, ethnic profiling. And the most recent case, also another case of 2020, with this person that had murdered an Azeri, an Armenian that had murdered an Azeri in Hungary, put in prison, then shifted to Azerbaijan, where he got presidential pardon, and he was basically glorified as a hero because he had murdered an Armenian. That was also the court concerned this was a prima facie case. My conclusion, I'm really there. Final thing. So there's been this very mixed account, if you like. The two-step analysis seems to fit the reasoning of the court in terms of its assessment of human rights violations. In terms of indirect discrimination, the sharing of the burden of proof is certainly there, firmly established. It's a way more complex picture in relation to direct discrimination. There are some developments. I've shown them more or less in my presentation. In the end, I think it's fair to say that the court is still called upon to give more guidance about the relevant parameters for a prima facie case, which is critical to operationalize the shared burden of proof and thus the effective protection against racial discrimination. Thank you very much, Michael, to allowing me these few minutes extra. Thank you all for your attention, and I look forward to question times.
Thank you, Kristin, for that very illuminating presentation.